Now we'll discuss the application of Article 14 into different fields, and regarding the very application of Article 14 into different fields, we categorize all these areas into three divisions. The first division is regarding admission to different colleges and universities, and the second one that is relating to service matter, and the third division that is dealing with all other matters. So regarding the first one, that is relating to illegal denial of admission, and in relation to that we'll discuss the first important leading case, S. Krishna Shraddha versus State of Andhra Pradesh in 2017, as decided by the Supreme Court, that in case of breach of illegal denial of admission to a meritorious student, monetary compensation cannot be adequate and shall relief, because the depreciation affects academic career of the student. And in the second leading case, that is relating to S. Nihal Ahmad, and it is relating to medical college and hospital and research institute admissions, and it was decided in 2015 by the Supreme Court. And in relation to that, the apex court pronounced that if the candidate is deprived of admission to medical course due to the fault of medical college, and admission cannot be granted after lapse of cutoff date, then the medical college is liable to pay compensation to him for loss of 1 year of his career. And the same decision was repeated in the leading case, Chandigarh Administration versus Jasmine Kaur in 2014 by our Supreme Court. And now we'll go to another important leading case, and that is SGT Chamanlal versus Union of India, and it was decided in 2017 by our Supreme Court, where it was pronounced classification based on medical categorization is not singularly dependent on percentage of disability suffered by the candidate. It also depends on other factors. And now we'll go to the next important leading case, and that is relating to Ram Kumar Gijaria versus Delhi Subordinate Service Selection Board in 2016. Supreme Court expressed that the candidature of the candidates cannot be rejected on the account of the late submission of caste certificate for the post of staff nurse, as it was declared in this leading case. And now we'll go to the next important leading case, and that is relating to state of Rajasthan versus Ashok Kumar Gupta in 1989, as the Supreme Court expressed its expression that is relating to education and matters in admission, and in that particular leading case it was relating to that the Supreme Court pronounced for admission to LLB course in the Department of Laws in the university, reservation of seats for employees of the university and their wards is unconditional, and it has no reasonable nexus with the object of selection, and as it was also declared in the same case, Asundar Kaur versus Punjab University, and so also in state of Rajasthan versus Ashok Gupta. And now we'll go to another important leading case relating to that field, and that is relating to G. Bina versus Andhra Pradesh University of Health Sciences in 1990. The Andhra Pradesh High Court declared that rules of admission to medical courses specifying length of service for purposes of claiming admission in the quota reserved for children of ex-servicemen are valid. And now we'll go to another important leading case, and that is relates to Kerala. So, in this leading case, Akhil P. Puskar versus State of Kerala in 2012, the Kerala High Court expressed that the benefit extended to scheduled caste and scheduled tribe students by way of fee concession cannot be denied by making an in-house classification among scheduled caste, scheduled tribes based on any principle as it was declared by the Kerala High Court in this leading case, Anil P. Puskar versus State of Kerala, and it was declared in 2012 by the Kerala High Court. So, in our upcoming video, we will discuss regarding the very application of Article 14 in relating to service matters.